first case in 115990, State of Kansas versus Robbie A. Thomas.
Robbie Thomas appears through counsel Michelle Davis. May I please reserve 2 minutes for rebuttal?
2 minutes is granted.
Thank you. This is a case where around 5 days after the alleged event, third-party persons noticed bruises on the back of a 2-year-old boy and burning on his bottom, and the police were contacted. The state's evidence at trial was that Mr. Thomas lived with, I think, around 5 children. A couple of his kids were visiting, and the child, whom I'm going to refer to as Jay, he lived with the child's mother, and his daughter, who I think was maybe 5th or 6th grader, testified that the child Jay, the 2-year-old, had soiled his pants, and that Mr. Thomas was disciplining him, was very angry, and was cleaning him off in the bathroom, and the child was screaming. So on that basis, the state convicted Mr. Thomas of child abuse, which is cruel and inhuman punishment, and also level 4, knowing aggravated battery, great bodily harm, and then endangering a child for failing to get medical treatment for the child. Mr. Thomas's defense was that, the mother was also in the home. Apparently there were 2 working parents that shared child caring duties and could have inflicted the injury, and also that the police never went to the home and checked out whether the water was capable of getting to a temperature where it could burn a child like that. And Mr. Thomas said that the hot water heater in the home was defective. And that was his defense. We raised several issues on appeal. The judge misstated the law in instructing the jury on what the state had to prove for aggravated battery. And the prosecutor made errors in closing argument, some of his statements to the jury. These errors together are cumulative error. And then the fourth is the court erred in scoring a prior conviction as a person offense. And it's my understanding the state's going to concede that last issue on the basis of Wettrich. So I will proceed primarily on the other issues. With the misstatement of law, basically the judge told the jury that the state, to have knowing aggravated battery, the state was only required to prove knowing conduct, and the state was not required to prove knowledge of the harm that could result. In other words, aggravated battery is knowingly inflicting great bodily harm. And that's kind of the difference between aggravated battery and child abuse. Child abuse is more focused on the conduct, that you actually, cruel or unusual punishment. And so basically when you tell a jury that aggravated battery is just knowing your conduct, that you don't have to know that your conduct is reasonably certain to cause the result, that meant that the state wasn't required to prove that other element. The state basically then, and that was their closing argument, they just focused on Mr. Thomas's conduct, and basically the state's theory was he's got all these kids, he's working, he's sick, he loses it, and he goes into this rage, and that he inflicts these injuries on the child. And so by failing to tell the jury that the state also has to prove that he acted knowing that he was causing great bodily harm to the child. The state never had to prove that based on the court's jury instructions, that was error and that it's reversible error. The reason that error, I think the difference in the Court of Appeals in finding it harmless is, again, because of this theory, the state never really had to prove it. This theory that Mr. Thomas testified, and in terms of his credibility, that he said he didn't believe the water could get that hot. So basically, even if you accept the state's evidence that he flew into this rage, and that his conduct was unacceptable, it's another step then to say that he really believed he was causing great bodily harm, or he could cause great bodily harm. Because if the hot water heater if he believed that water couldn't get that hot, then there's reasonable doubt there on that element, because a lot of it goes to the basis behind his actions. And again, the way the state argued this theory of the case, the state basically argued this as a typical child abuse where a parent's disciplining a child and they go too far.
I'm not sure I understand your argument, because the defendant's real defense in this was either that he was innocent, didn't do it at all, or that it was negligent. And so there's no intentional component to either one of those defenses. So how does it impact the case that the defendant was presenting to the jury and that the jury rejected?
Well, basically the jury could have had sympathy with him that this was a parent in a disciplining situation. And so it goes to did he knowingly cause this result? Was he setting out acting? Was he acting in a way where he knew that he was causing great bodily harm to this child? And that's a little bit different.
Well, but your burden here on appeal is to firmly convince us that the verdict would have been different,
Right.
not just whether something might have happened.
I'm not really saying that something might have happened. I'm just saying, I remember Hannah, his daughter, who was the state's main witness, the 6th or 7th grader, she testified her dad wasn't abusive. I mean, this is a situation where a jury could have felt, yeah, this is a child abuse case, and the state's proved that, but they haven't really proved he really intended to do this to a child. Intent's not the right word, it's knowing. He acted aware his conduct that was going to cause this result. That's another step. And so the state points to the injuries and said, oh, these injuries are so terrible. And that's true. I mean, but that still just supports the child abuse case. It doesn't support what his thought process was.
Ms. Davis, on the harmlessness, how do you deal with the daughter's testimony, though, that this went on for 10 minutes with the child screaming throughout and the father asking, have you had enough?
Well, I think if you pursue the state's theory of the case that I think it was with the shower one that he was cleaning the child off. If the child got burned, the state's theory is the child would have got burned by the scalding water. The child's going to keep screaming with what's going on. And again,
Right.
this is horrible,
The daughter's
but-
testimony seems consistent with the state's case.
Right, but if the child's burned, the child's going to keep screaming, and that doesn't mean that he understood that. That doesn't mean he understood that the water was that hot and that's what was happening. The burns showed up the next day, was the testimony. So again, you're being asked to validate a conviction that was obtained without a jury having to find a key element of the crime.
But it seems like you're asking us to suspend common sense. Because usually if water is hot enough to burn, and you're standing there with a shower wand, you're going to
Yes.
recognize that is hot water.
But-
And I think
Right.
that would be a logical conclusion the jury could reach and seems to have reached in this case.
Right, but it's hot enough to punish the child or hot enough to cause great bodily harm. That's the difference. And the state never had to prove that. The state never had to prove that difference. The state never investigated whether the water was hot enough. The state never investigated. I mean, there was no evidence at all that he understood, that Mr. Thomas understood that showering the child off was going to cause this kind of injury. And that's what the state has to prove. And we don't get to see the credibility of the witnesses. Mr. Thomas testified. And again, they could have believed him and what he said in his testimony, that he didn't think that the water in the house was capable of producing these kind of injuries. And all it took is one juror to believe that. So I do want to quickly talk about my second issue too, because I think this is the one where the prosecutor showed the jurors the photos and said, if you think it's okay to do that, then find him not guilty. And basically it's our contention that basically the state's inflaming the jurors' emotions because the jury's not supposed to convict on whether they think this is okay or not. The jury's supposed to convict on whether the state has proven the elements of the crime based on the evidence. So it's also outside the evidence. And in fact, I mean, the defense counsel pointed this out. If you look at the closing argument, defense counsel said they're trying to divert you away from the lack of evidence. That the police didn't investigate this, and that he said in closing argument that they're appealing to your emotions. I mean, the defense counsel responded that this is clearly what the state was doing. So basically, that's improper argument because they're supposed to argue the facts and how the facts apply the law, and not sort of shame jurors into saying, if you think this is okay to do to a child, then you vote him not guilty. So again, it's sort of pitting jurors against each other too, because any juror who sort of thought that the state hadn't proven an element of the crime would have difficulty kind of supporting that verdict because the prosecutors already said, would you do this to your child? If you don't think this is okay, you need to vote guilty. And so basically that's the argument behind that issue. So that would conclude my comments unless there are questions.
Could you please address the sentencing issue? Because I understand you have indicated that the state is going to basically concede on that issue, but I have some questions as to that result.
Okay.
So could you lead me through what your analysis would be post-Wettrick on that issue?
Yes, and so basically Wettrich, we have the identical or narrower rule. It was a Virginia assault and battery that they used that they scored as a person offense. And it's our contention that Virginia prior is broader than the way Kansas defines, because Kansas defines as knowingly causing bodily harm or physical contact in a rude, insulting, or angry manner. Virginia, I tried to cite cases. Virginia relies on the common law definition, and so I tried to cite cases that were around the time of Mr. Thomas's conviction, and the cases that I got were basically Virginia is broader because it's a touching without consent, justification, or excuse. And so it's broader because Kansas requires it done in a rude, insulting, or angry manner, whereas Virginia, if you take it to the extreme, it's really just any touching that's not justified or excused. So, to my mind, that's broader because Kansas more prohibits a certain manner of touching.
Is it, and maybe this is a distinction without a difference, but they start with the statement that a battery is done in the spirit of rudeness or insult. But then there are exceptions to that, which are, at least as I read their case law, that the touching is justified or excused or there's consent. And I don't know, maybe those are mutually exclusive, but it's the way they write it is, it seems to me that they state this is the universe of our unlawful touching, but the touching is not unlawful if one of those things exists.
So I'm not sure I'm understanding your question.
Well, is it then any broader than Kansas when the universe is all touchings that are done in a rude or insulting manner?
So I guess we disagree on which case law. The case law that I relied on, I didn't see that. I just saw touching without consent, justification, or excuse. And so I just have to go back to the cases in my brief and to see.
I'm looking at Perkins
At
versus
Perkins?
Commonwealth.
So I don't know if that's a case I said. Okay, maybe I did say if the touching is lawful if the person consents, or if the touching is justified or excused. So again, I guess it just goes to I think we're still seeing this as a bigger category. But I'd have to take another look at that case.
Okay. Thank you.
All right.
Other questions? Thank
All
you.
right.
May it please the court. Chris Elslager appearing on behalf of the state. And since this case originally went through the Court of Appeals up till now, there's been a passage of a couple of years, and in that time, a couple of things have happened. First, the original attorneys have moved on, so that seems to be my recent MO. I'm once again pinch hitting today. And then as my opposing counsel pointed out, the case law regarding how we categorize out-of-state crimes has changed a little bit. And under State v. Wettrick, I have to concede at the very least that the Court of Appeals below applied the wrong standard in its analysis. And just based on my reading of the Court of Appeals decision below, it seems to me that the Virginia statute, the way Virginia defines domestic battery, is broader than Kansas. Of course, the court, if you're welcome to disagree with me if you've done a more rigorous research than I have, but it appears to me that Virginia also includes what we might consider assault rather than actual battery in their common law definition. But as I noted, I'm pinch hitting today, so I could be wrong. However, I do believe that at the very least the Court of Appeals did apply the wrong analysis in holding that it doesn't need to be identical or narrower, that it just has to be comparable. And Wettrick obviously overruled that. And in fact, the case that the Court of Appeals relied on more was overruled, I think, or was reversed by this court the day before the petition for review was granted in this case. So I came today prepared to concede that issue. But then moving on to the remaining issues, the one that I think took up most of the time this morning had to do with the jury instruction. And again, I have to make a concession, as the state did below. The jury instruction was erroneous by including too many alternative definitions of knowingly. However, I believe the Court of Appeals got it correct in the end result.
Well, was it alternative definitions, or was it just the wrong definition?
Well, depends on how you look at it, but they were wrong, and certainly wrong for this case. They should.
Well, was the right definition ever given?
The right definition was given. It was
And
that the defendant was aware that his conduct was reasonably certain to cause the result complained of.
And can you point me to that?
Well, I would have to refer to the briefs and the Court of Appeals opinion.
This is, correct me if I'm wrong, my understanding is jury instruction 6 had a correct statement, but that was with regard to child abuse. But instruction 12, which dealt with aggravated battery, said it incorrectly. Is that right?
Your Honor, as I noted at the outset, I am pinch hitting today. I did not write the briefs in this case, and I'm not thoroughly versed in the record. I relied on the primarily on the
Well, let me ask you a
Court of
related
Appeals
question,
recitation of the facts.
which you may or may not know. But aside from the instructions themselves, did the state argue aggravated battery under the correct definition of knowingly or not?
I believe so. If you look at the closing argument, the prosecutor focuses closing argument on the correct alternative of knowing that the defendant's conduct was reasonably certain to cause the result complained of. I believe that's quoted in the Court of Appeals decision. And again, I rely on I believe that the Court of Appeals recitation of the fact is correct. So I think when you look at that and you have to look at the standard of review, because the defense did not object to the instructions given, so you look for clear error. And under the clearly erroneous standard, it's only reversible if you are firmly convinced that the jury would have reached a different verdict had the error not occurred, and the burden is on my opposing counsel to prove that. When you look at in light of the evidence presented, I don't think there's any doubt that even if the error had not occurred, the result would have been the same. As Judge Lehman pointed out, this was a 2-year-old with severe burns to his buttocks and genital area, and the testimony from the 12-year-old daughter was that while this was happening, the little boy screamed like he was being killed or stabbed, and that this went on for about 10 minutes. And I think that length of time is important, because if it was just negligent or accidental, or the defendant didn't intend for this result to happen, or didn't know that this could be a result that could happen, he would have stopped immediately when the boy started screaming like that, not gone on for 10 minutes. And
But you're asking us to presume that that's what the jury would have concluded.
Well, I think no. I think that what you have to do is you have to look at the error that occurred in the instructions, and then you have to analyze. Well, if we take those couple of erroneous instructions away, would the result have been any different? And in light of this evidence, and in light of the prosecutor's argument,
I understand the standard, but here's what I'm struggling with. You've got jurors back in the jury room deliberating, and they look at the instruction and they say, all the state has to show is that he intended to spray this water.
Well, I think,
and so the elements are met.
if you take away the error and you look at if the instruction, the only instruction was given them is that the defender was aware that his conduct was reasonably certain to cause the result complained of, would the result have been the same? And I think it would be, and therefore they have not met their burden of showing clear error, because the result would not have been different but for the error.
So your argument is that what we should do is pretend that instruction 12 had never been given?
I don't think you pretend it has never been given, but you look at the case.
I just don't understand how you unring
the standard
that
of
bell.
review says that if the error had not happened, would the result have been different?
If the error had not happened mean if instructions 12 had been correctly worded?
Yes.
As opposed to it hadn't been given.
And if it had been correctly worded, we still would have reached the same result in light of the evidence. That I don't think there's any possible other result in light of the evidence given, or the evidence presented, and the argument of the prosecutor, which did correctly focus the jury on the defendant's conduct being reasonably certain to cause the result complained of.
Do you know
And I
if
think-
the defense made a mental state argument? I.e., I mean, it sounds like that was one of the defense's arguments.
My understanding from reading the Court of Appeals opinion in the briefs is that the defendant's argument was that it didn't happen. I think initially he claimed that the boy just jumped in the hot bathtub, which was refuted by the medical evidence because he didn't have any burns on his feet or knees or anything like that. But again, I'm relying on the statements in the Court of Appeals decision and the briefs that his defense was that no, it didn't happen. But I think when you circle back around and you look at the evidence that actually was presented, especially when you look at not only the injuries the boy had and the testimony of the girl that said this went on for 10 minutes with him yelling at him, have you had enough? There is no possibility that the outcome of the trial would have been any different if the instruction had been absolutely correct.
So, in other words, it's just overwhelming in your view?
In my opinion, yes.
This fits under the Nieder line, that even if you've got a incorrect instruction or an absence of an element, really we've got kind of an absence here of a correct element, then the evidence is comparable to a situation where a defendant is obviously over 18 and that's what gets omitted. I mean, it seems different in character to me somewhat here.
I don't think it's quite the same as, I don't really think we have a missing element. I mean, the element is there, and the jury was properly instructed on it, but they got some other confusing instructions. But they were properly instructed, and the prosecutor's argument focused them properly on that, on how they should approach that element. And because there was no objection, I mean, again, the standard review is important. There was no objection to it, so we have to look for clear error, which means you have to be firmly convinced that if that hadn't occurred, that somehow that the trial would have come out differently, and the trial would not have come out differently. The evidence, there's no other way to, there's no other outcome that could have happened under this evidence, and if you were to reverse and send it back with the correct instruction, the exact same thing is going to happen. You'll be convicted again because the evidence clearly points that way.
I understand your argument, and I understand the overwhelming nature of the evidence, but the part of the instruction that was given for aggravated battery seems to diminish the requirement that's reasonably certain to cause the result complained of that's required in knowingly by saying the state is not required to prove that the defendant intended the precise harm of the result that occurred. That's part of the definition. So it diminishes the requirement of reasonably certain to cause, if you see what I'm getting at. And it's back to what Justice Stiegel's point was, is that they never really reached the question because they didn't have to because of this definition. And that part of it takes away from the burden of showing knowingly that reasonably certain to cause the harm. I'm not sure if I'm making sense to you, but it just seems to me the instruction that's given took away the requirement. And so it's just hard. We're really dealing in again, I know we're talking about overwhelming evidence here, but
Well, and aggravated
help me
battery
here with that.
Is not a specific intent crime unless I think it's still a general intent crime, although it has a bit of a hybrid to it based on the case law.
Right.
That you have to intend more than just the act, or to knowingly do more than. But that's where the reasonably certain to cause the result complained of comes in. So, if I
But they were required not to prove the defendant intended the harm.
right, he didn't.
I mean, they didn't have to do that. So it takes away from that knowingly.
But I think that's in all aggravated battery situations. If I punch someone in the jaw, and I break their jaw, I didn't have to intend to break their jaw when I punched them in the jaw. In fact, probably I didn't. But I just need to know that it's reasonably certain that if I punch them in the jaw, I could break their jaw. And I think that's what they're getting at here. It's the same thing, and that's why while aggravated battery is a general intent crime, it's sort of a general intent plus. But I think that was covered here with the instruction that the defendant's conduct was reasonably certain to cause the result complained of. And when you look at the evidence here, again, spraying a little boy with a shower wand so hot that he screams like he's being stabbed and killed, and you do that for 10 minutes, I think that certainly meets the criteria of reasonably certain to cause the result complained of. So again, I think my opposing counsel cannot meet the burden of establishing clear error.
Counsel, since you're in the mood for conceding error, maybe not reversible error, but error, we can agree, can't we, that prosecutors can't get up in front of a jury and say, if you think this conduct is not okay, then you should convict, right?
I would agree in context, because I know where you're going.
Well, I'm going where this case is.
Right.
And I know what the facts are, and I know what the prosecutor said. That can't be right.
Because you have to look at the context. What the element of the crime was cruel and inhumane punishment. So I think where he said okay, you have to insert that element of the crime. The prosecutor saying, okay, if you think this is not cruel and inhumane punishment, i.e., this is okay punishment, not cruel and inhumane, then you can acquit. However, if you think it is not okay, that is, that it is cruel and inhumane, then you can convict. I mean, there is, the English language has a certain amount of flexibility to it, and in that flexibility, I mean, what is cruel and inhumane? Cruel and inhumane to the jurors using their common sense would be not okay. If using their common sense they think what the defendant did was okay, well then it is the conclusion is that it was not cruel and inhumane. And I think that's all the prosecutor was doing, was essentially equating okay for that element of the crime. Okay, not okay.
Can kind of see that argument as to one of the passages, but I'm having trouble with that when it said in the passage of context is, where did Thomas's daughter say this happened? In their home on July 2nd. He was disciplining for potty training. It's simple. Do you think that's okay? Do you think that's okay to do to your child? Then you better acquit him, but if it's not okay, you better find him guilty. That's Record Volume 8, page 160. How do we explain that passage?
Well, again, I think that if you look at you have to look at the entire argument rather than pulling individual statements out. I think in the entire context, my reading of that is he's still talking about the cruel and inhumane punishment. If you look at the paragraph just above that, he talks about the elements that the state has to prove. He says each of these claims must be proven that he knowingly inflicted cruel and inhuman punishment on the child. All right, this is the evidence that's been admitted, and he goes on and on, and then that statement comes in as he's talking about the elements of the crime. So I think you have to read it in the context of that he's talking about the element of cruel and inhuman or inhumane punishment. And I know that is certainly the analysis that the Court of Appeals applied and the conclusion they got to, and I submit to you that the Court of Appeals got it correct. And if there are no other questions, then that concludes my argument. I'd ask that you affirm the Court of Appeals as it relates to the convictions, and I can see that under Wettrick, the Court of Appeals did apply the wrong standard in analyzing the criminal history issue, and I will submit that to the court to determine the proper remedy for that. Thank you.
Ms. Davis?
I think it's the hindsight thing. I mean, here we are at 2019, but this case was 2015. And this court didn't come out in Hobbs in 2015. That's when this court said, what exactly is the knowing part go to of aggravated battery? The knowing goes both to the conduct and result. So I think everybody that was doing this trial was pretty much under the thinking and following the district court's instruction that with aggravated battery, all the state, it's the one that Justice Rosen talked about, the state's not required to prove that the defendant intended to harm or result. So I don't think there's much in closing argument
What about
that, because I'm sorry.
What about the state's argument that the proper definition was given in Instruction 6, I think it is?
So what the judge did was then he gave a shotgun instruction unknowingly, where he cited all of the different ways the state could prove knowingly. So basically, to me it's saying you could prove it, nature of the conduct, circumstances in which acting.
But one of them was reasonably certain to cause.
But it's basically saying this or this or this. And then when you combine that with this instruction about the state not having to prove the harm, and basically the jury can just go to that first, the nature of the conduct.
Do you disagree with the way the state characterized the arguments of counsel, i.e. that the state actually argued to the jury that it had proved reasonably certain to cause the outcome?
I think the prosecutor made a reference to that early on in his closing argument, the reasonably certain standard. But then as you go on through
Does that help us get over, I mean, I know you don't want
Right.
us to find harmlessness, but doesn't that help us reach a conclusion
So-
that the jury actually would have found that element had it been properly instructed?
I think when the prosecutor was talking about that, he was referring to the three types of knowingly that the judge had said, and sort of explaining the instruction. The problem is he never tied any facts to that. He never said these are the facts.
He wasn't
that
arguing
prove
from
that.
the evidence as we
Right.
heard today.
He was just more kind of explaining the instruction. And then if you go further through his closing argument, he's basically just pointing, to the photographs and saying, is this okay to do to your child? And basically just more, the contested evidence here was the conduct. Neither side really argued Mr. Thomas's mental state because that really just wasn't in play at this trial. So that would conclude my comments.
Thank you.
Okay, thank you.